President Biden is calling for historic changes to the U.S. Supreme Court. He's proposing three main reforms. First, a constitutional amendment that would prohibit a former president from getting immunity from federal crimes. That's a response to the court's ruling earlier this month about former President Donald Trump. The biggest change would be term limits for Supreme Court justices. Biden is proposing a system where the president appoints a justice every 2 years to spend 18 years on the high court. And the third is a code of conduct for the court. It would require justices to disclose gifts, refrain from political activity, and remove themselves from cases where they have a conflict of interest. Biden's proposals will face challenges becoming reality. ABC 10 News anchor Jared Aaron spoke with legal analyst Dan Eaton about this process.
The idea that some of these changes are going to take constitutional amendments. How tough is it for the president to propose something and get a constitutional amendment passed in the political climate we're in right now?
Well, I mean, your question answers itself. It's very, very difficult. I mean, obviously, first you have to get it through 2/3 of each House of Congress, which isn't going to happen, obviously, and then it has to go to the state. So there's a reason why we don't have all that many amendments to the U.S. Constitution, which has served us so well for well over 200 years. So it's very, very tough. And two of the three of them, term limits and essentially overruling the immunity decision the Supreme Court made, would take constitutional amendments.
Some of the people in the Democratic Party have been calling for President Biden to go even further than this and maybe add justices to the court. Is there any insight that you can offer on why that might have been harder, or why President Biden might have decided to go this way instead of just adding justices?
Well, there's an expression, Jared, that pigs get fat and hogs get slaughtered, I suppose. I mean, the Constitution actually does not set the number of Supreme Court justices. That can be done legislatively, and there have been a range of numbers with the Supreme Court. We've been at 9 for a very long time. So I don't know. I mean, he just picked and chose from the various proposals that were considered by his Supreme Court Study Commission, and why he chose some and not others is interesting. Interestingly, Jared, though, a lot of people are going to compare this to FDR's court packing plan that was announced in 1937. But the political context of that plan could not be more different from this, because FDR was coming off of a landslide re-election in 1936 where he defeated Alf Landon. Here you are talking about a lame duck president on his way out with not a whole lot of leverage in persuading Congress to go his way, and a sharply divided Congress at that.
So then, constitutionally, Dan, what are some reforms that could theoretically happen in the near term if President Biden wants to leave this as part of his legacy, or even pass the torch to say if Vice President Harris becomes the next president, that she can continue to work on?
Well, I guess there are two key phrases in your excellent question. One is in the near term, the other is continue to work on. In the near term, the glib answer is nothing, because it's just not going to go through. And President Biden, who served 36 years in the Senate, knows that. It's an ongoing process. It's planting a seed for an ongoing discussion. And the political consequences of that I'll leave to other people, but other commentators. But in the near term, nothing's going to happen, except it's going to engage the public, and it is going to be part of the debate leading to the selection of the next president of the United States, who will not be named Joe Biden.
All right. Legal analyst Dan Eaton, always a pleasure to get your insight on some of the biggest issues, especially facing the Supreme Court. Thank you, Dan.